Good morning. Are you Lisa Pratt?
I am.
So, Ms. Pratt, your case was set yesterday and you weren't here.
Right from the start, Judge wastes no time calling out Lisa Pratt for missing court. But here's the twist. This isn't just a no-show Casey. It's about trust drug testing and a bond on the line. Watch how this calm morning hearing turns into a high-stakes confrontation.
You're here on an initial. Do you have your drug patch on?
Do.
You do?
Mm-hmm.
When'd you get it?
The day before I left jail, which was almost 2 weeks ago.
All right, have a seat in the jury box. I'm going to have you tested this morning because that's not the information we got from Johnny's Auto. Have a seat.
Okay.
Come up, please.
Now pause here. Lisa claims she couldn't take a urine test because of a kidney tumor, which sounds serious. But in court, medical excuses don't override compliance conditions unless backed by official documentation. Judges hear every reason in the book, and they can tell when something's off.
Ms. Pratt, why won't you give me a urinalysis this morning?
Well, that's the same thing we went through last time. That's why I had the patch, because I found out that I had a tumor in my kidney
Okay.
while I was in jail. So that's why I can't urinate.
Okay. Because I have notification.
The lady came from Vienna to put the patch on. It was real late at night in jail.
So I have notification dated yesterday, the 6th, that you got a drug patch on August 31st when you were in the jail, and that they haven't seen you back to change or put another patch on you.
2 weeks ago, they didn't tell me to come back to check. They didn't give me a date or anything.
I don't believe
I
that.
thought I was coming today to get it taken off when I came, or yesterday.
That's not what that's not true. So I'm going to
I
find.
had the paper at home.
Oof, she says she was in the parking lot yesterday. That's the courtroom equivalent of saying, I almost did it. The judge isn't buying it. And when your bond conditions involve drug patches and you show up without proof, that a red flag.
I didn't bring it with me.
Well, you didn't show up yesterday. You didn't bring what you needed today. You haven't got your drug patch changed. You won't go to the restroom.
Well, she said 2 weeks.
Right.
You change it.
Yeah.
Yeah, so it's been that right now. I was going over there when I left court. I was here yesterday. I was in the parking lot.
You being in the parking lot doesn't do any good because I'm not in the parking lot, am I?
Right.
Okay.
Yes.
And there it is, bond raised to $20,000. That's not just punishment. It's a statement the judge clearly believes Lisa violated trust, the worst offense in pretrial monitoring. Remember, when a judge doubts your compliance, your freedom shrinks fast.
Your criminal history is prior felony possession of controlled substance cases. The fact that I have notification that you have not changed the patch like you're supposed to, and that you, in my opinion, appear to be potentially under the influence of something this morning. For the record, it looked like you were sleeping, having trouble staying in your chair.
I've been up all night crying.
Okay, I'm going to raise your bond this time for violating your condition of your bond, that you have a drug patch and have it changed every 2 weeks in the appropriate way. I'm going to raise your bond to $20,000. Condition of that bond, obviously, is that you have a drug patch. You got to figure out how to do it. You have to figure out, ask the questions, get it changed the right way at the right time, and then we'll see what happens from there. You go back with the bailiff. And Mr. Sanchez is on probation in cause number 18-30854 for the offense of driving while intoxicated, third or more. Was previously in court, entered pleas of true to counts 1, 2, and 3 in that motion to revoke his probation. And there was an unagreed, there was no deal. And I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, I have.
And I have received some objections filed, comment and objections filed by Mr. Franklin. Mr. Nichols, does the state have any objections or corrections to the updated report?
Not to the report, Your Honor.
Okay. And so with regard to Mr. Franklin, specifically, with regard to number one, that comment in there by the probation officer with regard to that it's unlikely that it was the first time, I'm not really going to take that into serious consideration. So that's not something that's going to make a big difference in what I do today or not do. So that one, I guess it's an objection that can be granted. With regard to number two, which has to do with a note in the records that you were able to look at with Officer LeBlanc asking whether or not a naturalized citizen based on their criminal history could still be potentially denaturalized and deported, and that has some type of race bias. That is also not something that is going to impact my decision, I think, as far as what I'm going to do in the case. I understand your position. Honestly, with the criminal history, which I know is another objection, we'll get to that and what's going on. I don't think it's improper to ask those questions, and I don't see anything else, especially she even put some positive things that he's done in this updated report, so it's not all negative. So I don't think there's a clear sign that there's some kind of racial prejudice or anything like that. So that's overruled.
Now the courtroom pivots new defendant, new tone. We're moving from bond violations to a probation revocation. Hearing these hearings decide whether someone gets a second chance or goes straight back to prison. Every objection, every word from counsel could change the outcome.
With regard to the fact that his prior convictions are inadmissible hearsay and too remote, in any motion to revoke probation or any case, prior offenses could potentially not be admissible for purposes of enhancement or sentencing in front of a jury. But as far as going into, especially when it's a driving while intoxicated, which requires prior offenses to get where we are, I think it is imperative on me to understand the criminal history, understand when those were, understand the remoteness of some of these, but it doesn't take away from the fact that you have to have those prior driving while intoxicated to get where we are now. And so I'm going to overrule that objection with regard to the prior convictions. Any witnesses today by either party? Does anybody have any witnesses?
I have no additional witnesses, Your Honor.
Your Honor, we previously submitted letters of support.
Yes.
And we believe those are in the record and the court has reviewed those. I just wanted to note for purposes of today that we have filed those. They have been reviewed by the court, and we hope the court has taken those into consideration and considering sentencing as well.
I will, and I did. And let me pull them up again just because I think that's been...
So specifically, they were not admitted for this purpose. They were admitted for bond.
Okay, that's right. Thank
for
you.
purposes of bond.
Okay.
However, the letters of support, the information in them speak to my client's character and the support by the community.
I see them right here, and I did review them obviously for that, and we'll take them into consideration for this hearing as well.
Thank you, Your Honor.
Anything else?
Your Honor, just in response to the analysis of the court's overruling of the objection, we would point out, as noted in the PSR, there is a substantial time in between the prior convictions and the current one for which he's on probation. And we hope that the court was able to look at that and consider that from 2001 to 2018, there was a major gap. And then by all accounts, by the admission of the probation officer, Mr. Sanchez has had minimal violations, was not a supervision problem, made efforts to be in compliance with probation. And although he did plead true to the current violation, he has shown 5 years of continued compliance. And we ask that the court consider the gap in history, the 5 years of compliance, as factors to keep him on probation.
Thank you, Mr. Franklin. Mr. Nichols?
Your Honor, this case was originally pled as an 8-year cap. I'd argued for Penn Diamond at its original sentencing 6 years ago. I'll acknowledge he's been mostly done well on probation except for the new offense and the new violations that are alleged that he did plead true to. And I agree that his criminal history, while somewhat extensive, is rather remote. So I think those factors give the court enough information to make a decision. I am in favor of revocation just because it is another DWI offense.
7 years, the judge actually went lighter than expected down from 10Y because of the long gap in offenses and good probation record. But make no mistake, one bad decision behind the wheel and even a decade of good behavior can vanish in minutes. What do you think? Was 7 years fair or too lenient?
But as far as the length of time, I think the court has enough information to make a just decision on that.
So, Mr. Sanchez, the issue, I understand Mr. Franklin's argument as well as Mr. Nichols. You did have a substantial amount of time where you were able to not drink and drive. The history is old, but then again, you started it up again, in my opinion. You got this DWI, and so you had, there's a couple back in 1995, and then there's one in 2000, and then you had this one in 2018, and now we have another DWI that you have admitted to in another county where you were driving a vehicle without the interlock and under the influence. And at this point, I feel like we're all lucky that you have not, that we're here on a DWI, not an intox assault or an intox manslaughter or something like that. At some point, you've got to figure it out. You're on probation for the same offense. So I'm not inclined, and I don't think it's in the best interest of the community for you to remain on probation. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I am going to take some of the good things that you've done in the length of time into consideration. I had initially marked on this pre-sentence report that I should probably give you the full 10. Mr. Franklin makes some good arguments with regard to the length of time that you went without being in trouble. It looks like you did well with some things on probation, but the main thing, you didn't. And so at this time, I'm going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you a trial court certification. I need y'all to sign this real quick, Mr. Franklin, that shows that this was not an agreement. So you do have some rights to appeal. Once y'all sign that, I'll tear off that bottom copy for y'all if y'all signed at the bottom. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, then you can talk to Mr. Franklin. And I'm going to go back. I'm not sure if I'd said it exactly properly. I am going to reassess your punishment because you were already assessed a 10-year term. Reassess that punishment at 7 years. And here's that firearm, Mr. Franklin.
Thank you, Your Honor.
This is just going to go, this is to go in the pile after trial, yeah. Let's see. The bottom 2 copies are y'all's if you want to tear those off.
I think you pressed very hard, Judge.
That's okay, as long as my signature came through, I'm okay, because I get the top 2 with his on it. Give me one more of those. There's 4.
I'm so sorry.
Nope, you're good. Perfect. Thank you. All right, sir, you can go back with the bailiff.